you had chat, Ms. Tusky. Yourself up. And then Ms. Underwood, Ms. Spiegel's in the first row. So would you like to start with Ms. Carver and then go talk to Ms. Spiegel? All right, so Ms. Carver and Ms. Underwood, step up to the podium. Are you on? Who's got me? Okay. So,
Judge, we're doing an echo. I think he's at the left side.
Oh. Rhonda's got me on Zoom too. I'm gonna put you in the waiting room, Rhonda.
Sorry.
Okay, that should take care of it. All right, so this is in the matter of the people of the state of Michigan versus Jasmine Carver. And this is file number 24-21740FH. I have Rhonda Underwood appearing on behalf of Ms. Carver. This is the date and time set for sentencing on a misdemeanor. So, Ms. Carver, have you had a chance to review the pre-sentence report with your attorney?
Yes.
Okay, I need you to step over by Ms. Underwood and I need you to speak loudly into the microphone. Can you repeat that?
Yes.
All right. Now, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do not, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, it does not, Your Honor.
Okay, so, double check something. So on the judgment of sentence, it states that she pled guilty to count 2 domestic violence 3rd degree, but is that correct?
It was a 93-day with a 769, I believe is what we arrived at.
Okay, so when I look back at, or if I look at the felony information, count 1, and the reason I asked this is because Mr. McCarron had a question about it. Count 1 was child abuse 3rd degree, which is a 2-year felony.
Right.
They added count 2 domestic violence, which is a 93. That's not a 3rd degree, correct?
It's not a 3rd degree.
So my judgment of sentence and the plea reduction form had an error in it. So that needs to be amended, correct?
Correct.
Okay. All right. So we will have the judgment of sentence changed.
I just want to make sure everybody, and what was negotiated at the time was a 93-day domestic violence with the 769 conviction. And I believe that should be reflected in the court's notes.
Well, it should, but I want to make sure we do this correctly because right now it shows she pled.
We're all talking about the same thing.
Yeah, yeah. So it's not a domestic violence 3rd degree.
Judge, the notes in the file do not indicate an agreement to 769.4A.
which is part of my frustration with not having written plea agreements, because I don't know. They said no agreement to that. And I think the prosecutor has to consent to that.
I don't know, I'd have to pull the transcript and I can't do it today.
Yeah, we're gonna have to adjourn it. Because the notes in our case summary say, plea offers for DV, there is, and this is underlined, no agreement for 769.4A or 771.1 or anything like that, is what I have. Now, if that changed, it's not reflected in the
so-
questioner's notes.
What I would say is, Ms. Underwood, I don't remember what happened the day we took the plea, because I take so many and I send so many people.
Okay, we can,
So what I want to do is adjourn this.
okay,
And Ms. Adams, when can I adjourn this to? It could be a week, it could be whatever, because I just need to listen to the audio. I don't know if there were any notes, but you probably need to listen to the audio.
It is in the judgment, Judge. I don't know if that matters right now.
It does reflect that Mr. Sneed also approved it on the record.
Say it again,
Mr. Sneed was here and he approved it on the record, or what mine
the
was. reflect.
769.
Yeah.
So Ms. Spade looked at her notes, Ms. Arnold, and it does say that on the record, Mr. Sneed did approve a 769.
Miss Underwood stated it and then he confirmed it.
Ms. Underwood stated it and he did confirm. I mean, I can still adjourn it and we can listen to the audio if you'd like.
Yeah, if we can just be sure.
Okay.
Court doesn't mind.
Okay, so Ms. Adams, when can I adjourn this to?
I'm looking at July 5th at 8:15.
Can you come back on July 5th at 8:15? All right, and we'll listen to that today just to verify it. All right, so can I get a notice of hearing from Ms. Carver?
Okay.
And my judgment of sentence also says 769. So we'll pull the audio, but it does say domestic violence 3rd degree, which that is wrong. And that was part of something, I think it was because the child abuse was 3rd degree, but all right. So Ms. Carver, have a seat on that bench behind you. We'll get you a copy of a notice of hearing and then you're free to go and come back on that day. And then Ms. Underwood, if you want to go chat with Ms. Spiegel, she's in the first row.
Ms. Spiegel and I have chatted, Your Honor. I believe she's ready to go.
All right. Mr. Dagger Margosian, I have Mr. Washington in my waiting room. Do you need a breakout room with them?
Yes.
Okay, so if you want to either go in my jury room, you can walk through here, might be able to let you back. So if I'm correct, because I haven't been downstairs a long time, there is no domestic violence 3rd degree 93-day misdemeanor. It's still just the, okay. I didn't know if they added that, but never mind. All right, so Ms. Spiegel, let me get your file. Okay. This is in the matter of the people of the state of Michigan versus Brianna Lynn Spiegel. We have 3 files, 22-20816 FH, 24-21737 FH, and 24-21738 FH. Give me 1 second. Do you want this file? Here we go. Mr. Washington. if you want to go ahead and unmute your device, Mr. Washington, and start your video.
Hang this up. You
All right.
hang it up. No, I'm gonna hang it up. No.
Mr. Washington, Mr.
Yes, I'm
Washington.
trying to unmute
No,
it
it's,
now.
no, it's okay. Listen, in a minute, you're gonna get a request to join a breakout room with Michael Dagger Margosian. So go ahead and join that breakout room.
Okay.
All right. You should have just got it.
It's-
Okay, so Ms. Spiegel, back to you.
Okay.
So this is a date and time set for sentencing, so I have a couple reports on file number, let's see, 22-20816FH. I have a probation violation recommendation report. And then I have a pre-sentence investigation report on file number 24-21737FH and 24-31738FH. So Ms. Spiegel, have you had a chance to read and review those reports?
Yeah.
Okay, now you gotta speak up so we can get this on the recording. Okay. And have you had an opportunity to discuss that with Ms. Underwood?
Yes.
Are you satisfied with her as your attorney and the advice that she's given you? All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any of the information in either report?
We do not, Your Honor.
All right, on,
We don't wish to challenge anything, Your Honor.
I'm sorry?
We don't wish to challenge anything. Your Honor.
Okay, so on file number 24-21737FH, the probation department has calculated the guidelines to be 0 to 11 months. Do you agree with that calculation of guidelines?
We would agree with that.
And then the same on file number 24-21738FH, they calculated the guidelines to be 0 to 11 months. Do you agree with that calculation?
Yes, we would.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Ms. Spiegel?
Just that I think Mrs. Spiegel has used her time wisely, Your Honor. I think she's prepared to really put her head down and complete this probation that the court and the probation department, through their recommendations, have given her the opportunity to do. She appreciates that very much. Ms. Spiegel wants to complete this, Your Honor. The one concern she has is her family is scheduling a vacation later this summer up north. She hopes to work with probation to be allowed to go on that because it's the first time she's spending time with, I think, their father.
My father and my
in a long time.
brother and
So, but Ms. Spiegel really wants to work hard at the court, Your Honor, and her probation, and she looks forward to success.
good job.
And Mr. Coast, have you worked with Ms. Spiegel at all?
I have, Judge, since she's been out of jail. She's been doing twice weekly drug screening, and she doesn't miss, and every single drug screen has been negative. She's done an excellent job with me.
Excellent. Okay, Ms. Spiegel, anything you want to say on your own behalf?
No, I just been changing my life and I feel great. I got a job now.
Where are you working at?
Curb appeal construction.
Nice.
Siding.
Okay,
And I go to AA every day. I go to church with my mom and my grandma on Sundays. Like, I've been doing very good and I love it.
well, you look healthy.
Thank you.
You look like you're in a better place.
I want to go to this thing on the 20th of July for a week with my family, and that's the only thing that I really, really want to do.
Okay. Well, I will say that Ms. Teskey knows, the policy is if you're doing well, we
Yep.
allow these things, but if you're not doing well, you don't. So
I'm
it's
doing
all
good.
dependent on you, and Ms. Teskey will always reach out to me to see if I grant permission, all right?
Okay, thank you.
All right. Anything else, Ms. Underwood or Ms. Spiegel?
No, Your Honor.
In determining the appropriate sentence in these cases, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. On file number 22-20816FH, which is the violation of probation, sentence the court that your probation will be continued and you will enter and be involved in the Lenawee County Recovery Court following all rules and recommendations made by the same, okay? And then on, let's see, let's go to file number 24-21737FH. I'm gonna place you on probation for a period of 3 years. During your term of probation, no controlled substances, can't use alcohol, and that includes marijuana because you're in the drug court program. You understand that? Must test as required, not to possess any paraphernalia or any substances. Any prescription narcotic drugs, first your physician needs to know that you're an addict and that you have to get approval from Ms. Teskey before you take it, unless it's like an ER situation. You understand that? Do you have your GED or diploma?
I got scheduled, but I had to
Okay.
be at work that day, so I had to reschedule it.
So they have some great programs in Lenawee County to work on that.
Okay.
Understand they can enter your house, your car, look at your phone, your computer at any time if they have reasonable cause you violated your probation. All right, maintain employment of at least 30 hours a week. There's a $130 crime victim rights fee, $30 supervision fee. But if you need a tether, it'll be 60, all right? There's $750 in court costs, $450 in attorney fees, $68 in state costs. You must attend and complete the Lenawee County Recovery Court and follow all recommendations. You still have a large arrearage on your probation violation file. So Ms. Teskey will probably set up a monthly amount you have to pay, okay?
Yeah,
Also,
I paid last week. So.
yeah, but it's easier if every week you get paid, just put some money on it.
Yeah.
But also some of that can be worked out in community service.
Okay.
Okay.
Yep.
On file number 24-21738FH, I'm gonna put you on probation for a period of 3 years, all the same requirements and any other requirements that they add, you will obey and comply with.
Okay.
On that file, there's $130 crime victim rights fee and $68 state costs, and then you must enter and complete the Lenawee County Recovery Court. Ms. Teskey, anything I'm missing?
No, Your Honor.
All right, so Ms. Spiegel, you know, it's hard to be sober. That's the one thing I hear from people, because you have to deal with the heartache, you have to deal with the difficulty, you have to deal with the stress, which is something when you're an addict, you don't do, right? But you're doing really well, you look healthy, you look happy. So I'm glad to see that. You know, I hope you enjoy the recovery court program. It's a good program.
I started it.
I know. So it's a good program. So my bailiff's gonna hand down to you, there should be 3 sets, right? Okay. Your notice of right to appellate review. He's gonna have you initial and date 1 copy for each file. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay.
And Ms. Teskey, when does she need to report to see you?
Tuesday.
Yep, Tuesday. Okay. All right.
Okay, thank you.
So Ms. Underwood, Mr. Clark, that's you, right, at the jail?
Yes, ma'am. Yes, ma'am.
Do you need a breakout room with them?
I don't believe we need a breakout room. We
Okay.
spoke yesterday, Your Honor. I reviewed his PDR.
Thank you. Excellent. Thank you. All right, Ms. Spiegel, have a good weekend.
Yep.
Thank you. All right, in the matter of the people of the state of Michigan versus Douglas Wayne Clark, we have two files. We have file number 22-20842 FH and 22-20843 FH. I have Brenda Underwood appearing on behalf of Mr. Clark. This is a probation violation sentencing. So Mr. Clark, Ms. Underwood zoomed in with you yesterday. Is that correct?
Yes, Your Honor.
And did she review the probation violation recommendation with you?
Yes, she did, Your Honor.
And you had an opportunity to ask her questions, is that correct?
I did, Your Honor.
Okay, are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor, I am.
All right, so Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence
Well,
report?
and I can't speak to its accuracy, Your Honor, but Mr. Clark did express some concerns, as I told the court, regarding time served, and I explained to him that I don't compute that, and normally the court doesn't compute that. That's computed by the jail. So I just want to make sure that whatever happens to Mr. Clark today, Mr. Clark receives credit for all time served.
Okay, so Mr. Clark, we have on both of these files that you were initially arrested back in April of 2022, and you spent about 2.5 months in jail. Does that sound right?
Yes, ma'am, almost 90 days, yes.
Oh, well, it was April 8th through June 29th. So, all right. And then your bond, I revoked your bond on October 19th, and you spent about 1.5 months in jail then, right?
Something, I don't remember exact dates, ma'am. I just remember what you gave me time served when you sentenced me. You gave me 3 years probation, 9 months in the county jail with credit for 9 months time served, and released me to drug court that day. But you gave me credit for 9 months time served the day I was sentenced on 9/21 of 23.
All right, let me look. I'm gonna look at your paperwork to see what I gave you. But I released you to programming?
Yes, that day, Your Honor. You gave me 3 years in probation, 9 months in the county jail, and then you gave me the 9 months credit time served because I had a non-deferred sentence in Ohio, because I was extradited back from Ohio Department of Corrections, if you remember correctly. And they had a non-deferred sentence, which Michigan could have come and got me 4 months into my sentence, and they never did. So you gave me credit for that time.
Okay, so Ms. Teskey, I'm gonna change that to 180 days because he was on a holder, I think, in Ohio. I think I remember that.
Yes, ma'am, I was.
Okay, all right. So, all right, other than that, Ms. Underwood?
Other than that, that's the only
Okay,
inaccuracy or question we had.
all right. Is there anything else you'd like? Oh, hold on,
So-
hold on.
I'm sorry, ma'am.
Mr. Clark. No, it's okay. Was there anything else you wanted to
No,
challenge in the report?
No, I just wanted to apologize to the courts for wasting time with the drug court, ma'am. I was just overwhelmed, and I don't know, man. I don't know. It was probably a bad decision on my part. I just wanted everything to be done. I don't know. But I've been doing good. I've been clean. I have relapsed once in the last 6 months, but I've been clean. I've been working. I mean, I'm healthy. I'm not, you know what I mean? I'm doing good. I really am. I just jumped ship, you know? But I appreciate the court working with me and maxing me out on this. And like I said, I just want to be sure that I got the 9 months credit for the time served that I had done.
Okay. All right, that's like 252 days is 9 months, Ms. Teskey. Is that about right?
Yeah, Your Honor, I was just trying to look it up. I was
like
just
300,
trying to
like
make sure
300
that we
days.
had this correct.
It's like 290, I do believe.
Well, 9 times 30 is 270, so,
Okay, you're right. No, I'm sorry.
all right.
Well,
I'll just go with
I'm counting in the 2 weeks that I've been locked up this time too. I'm sorry. I've been locked up since 10th, I think, or something like that.
the 10th of,
This month. They picked me up not this past Monday, but the Monday before. I've been locked up almost 2 weeks.
So I'm gonna give you 280 days credit. Okay. Is there anything
Thank
else you want to say, Mr. Clark?
No, Your Honor, other than I'm sorry for wasting y'all's time on drug court.
Well, it's our job, so,
I appreciate
you
the
know,
opportunity.
well, I hope you do it on your own, at least going forward. Anything you want to say on behalf of your client?
Just that Mr. Clark did express to me, he was very sorry. He respects the court and Ms. Teskey very much. And he's very sorry he squandered the opportunity he was given.
Okay.
Very much so.
So, and so there was a comment in here, you just said that you were kind of fed up because you felt like I didn't listen to you when you said you had bad knees or a hard time walking. You know, I get that people have pain, but you can be an addict in pain all the time. You have to want sobriety. And, you know, as we get older and, you know, frankly, you're getting older too, everything starts to hurt.
Yes,
And
ma'am.
so, but you have to work towards sobriety, whether it's riding a bike or, you know, whatever it might be, you're getting rides, there's a way to accomplish it. And I really feel that was kind of an excuse just to relapse. So I wish you the best of luck. So it's a sentence of the court that you will serve 1 year in the Lenawee County Jail. And we'll give you credit for 280 days already served, and we will revoke and terminate your probation on both files. All right, so we're gonna send, we're gonna send over to the jail your notice of right to appellate review, and they'll have you initial and date the top copies. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, Mr. Clark?
Yes, ma'am. Thank you, Your Honor.
All right, thank you. Good luck to you.
Thank you, Ms. Teskey. Have a good day. Thank you. Thanks, Ms. Underwood.
Good luck, Mr. Clark. I'm sorry. Do you have the Wilson case today?
Yeah, Michael Dagger-Margosian.
Frederick Wilson?
Oh, Mr. Dagger-Margosian said it's not him. But yes, I do. MDOC is not zoomed in.
No, he's here.
And he is here in person because I saw a ton of
Is
them.
he here in person?
Yes,
Yeah.
sure.
He's actually here today?
Yeah.
Oh, yay.
So you're gonna go chat with them?
Yes. I'll go.
Okay. So I'll mark in here, it's Rhonda Underwood. All right, so Mark Keith, Washington, and then Mr. Bernstein, I will be with you next, okay? And Michael, you have Oliveras as well, correct? Are you Oliveras? Because you looked at me.
Rhonda,
Rhonda,
first floor. Try the first floor.
he's on the first floor.
Oh, on the first.
All right, thank you. Are you here in Washington?
I am.
Okay, so this is in the matter of the people of the state of Michigan versus Markeith Isaiah Washington. We have three files, 24-21810 FH, 24-21741 FH, 24-21742 FH. I have Allison Arnold appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Washington. Did you guys need a minute to talk or?
No, Your Honor, I just wanted to put on the record, we did receive a victim statement from Sandy Swope, who originally was a victim in one of the files where her charges were dismissed and the defendant pleaded to R&O. So I'm not gonna be filing that with the court because her charges were dismissed.
Okay. Okay, so, Mr. Washington, I did place you and Mr. Dagger-Margosian into a breakout room this morning. Did you have ample time to speak with Mr. Dagger-Margosian? Oh, you're muted, Mr. Washington. Let's unmute you. Come on. Here we go. I just sent your request to unmute.
Yeah, they do this is bad. So they fun. Like, I don't know.
So I can't, hold on, everybody stop. So Mr. Washington, when you move or turn your head away, I lose audio on you. So you need to be close to the phone and speak into the phone. And then make sure if there's anybody in the background that they're quiet, because when we zoom in, it's necessary. So hold on, Mr. Coast. I do show we had a motion affidavit and bench warrant because Mr. Washington turned off his tether was turned off on May 28th due to non-payment. Do you have anything else to report on that, Mr. Coast?
That is correct, Judge. It was turned off on 5/28. I talked to Markeith. I told him to turn himself in on the warrant, that I was willing to work with the balance with him, that I was going to actually put some money towards his device to get it reactivated. He failed to show as promised. I did confirm with JSG this morning that the device is still off. So now it's been about 3 weeks since that device has been off. So he's not being safely monitored at this time.
Okay, and he's also being charged every day for that device, right?
That's correct, Judge.
All right, so Mr. Degemer goes in. I do have a bench warrant for his arrest or failure to keep his device turned on.
Well, Your Honor, I'm happy to address that issue.
Okay.
Regarding the tether issue, I did speak with Mr. Washington near the time of when this allegation came up. I spoke with Mr. Coast as well. I informed Mr. Coast that Mr. Washington, unfortunately, money is tight. Mr. Washington had been making payments on the device, but as the court can see, that payment did stop at some point. What I will say is that I don't believe that there are further criminal allegations, and obviously that's what a tether is supposed to do, and so is to notify and give notice and that sort of thing, but there are no further allegations, so I would say that he is somewhat in compliance with the purpose of the tether, so I would ask the court to take that into account. Now that today obviously is the sentencing, that bond condition of the tether would presumptively end, and so maybe what I would ask the court to consider is if I'm assuming Mr. Washington still has a balance on that tether, and so as a condition of probation, he certainly would be ordered to pay the back pay. But again, now that the bond condition would be done, I would ask for the tether to be removed, and of course, another condition of probation is to not get any more criminal allegations. So the ball is in his court at this point.
All right. Okay. So,
and I guess the only other thing I'll say is, and maybe it's jumping the gun, but the sentencing agreement in this case was for suspended jail. So that would also sort of tie in both of those conditions.
okay. All right. So Mr. Degemer goes in. I'll give you a moment to weigh in just a second. Do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No.
All right. So Ms. Arnold, do you wish to explain or challenge the accuracy or relevancy of any information in the report?
No, thank you.
Okay. Do you wish to weigh on the tether subject?
I mean, I just think if he's not in compliance with tether, taking him off it at this point might not be appropriate. It might be appropriate to leave him on it for a while longer until he can demonstrate compliance, because until he shows he can comply with what he's supposed to do, I just think he should stay on.
Okay. All right. Mr. Degemer goes in. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None to my knowledge at this time.
The probation department on count 2 on file number 24-21810FH has, wait a second. Is this an update? No. Okay. So on file number 24-21810FH, obviously there's no guidelines for the domestic violence, but on count 2, assault with a dangerous weapon, the probation department has computed the sentencing guidelines to be 10 to 23 months. Do you agree with that calculation of guidelines?
Your Honor, I don't have any challenges at this time.
Okay, and then on file number 24-21741FH, the guidelines were calculated on count 1 uttering and publishing to be 7 to 23.
No challenge.
Okay, and then on file number 24-21742 FH 0 to 17.
No challenge.
Any challenges or position on the guidelines, Ms. Arnold?
Oh, no.
All right, is there anyone who wishes to speak today? No?
No.
If you want to speak today, you can.
No, she's here for a different file.
Oh,
Yeah.
well, everybody's looking at me. I was like, okay.
Yeah.
Anybody else? No, not on this case? Okay. All right, so Ms. Arnold, is there anything you'd like to say on behalf of the people?
No.
Mr. Decker-Marcos, anything on behalf of your client?
Your Honor, as I alluded to, there was a sentencing agreement for all three of these cases for the sentence to be a suspended jail sentence of 6 months, as well as a probation term of 2 years. On the UNP case, of course, there is outstanding restitution, and that will be ordered as part of probation. Again, I would just reiterate that the issue with the tether, I understand Ms. Arnold's position on non-compliance, but I think the reason for the non-compliance is important to look to. And so here, it was strictly a financial obligation that he couldn't satisfy. So I just ask the court to take that into account. And if I recognize that the 6-month suspended jail would technically be a departure on a downward departure on the 10 to 23 guideline case. I think under the circumstances, it is appropriate. In speaking with Mr. Washington, he does want to straighten up, and on that point, he's also asking the court to, if allowable, to order some form of therapy for him to be a part of. He wants to move forward. He wants to better himself. Obviously, probation is the vehicle to do that. So I'd ask the court to go along with the sentencing agreement and place Mr. Washington on probation.
Are you still living in Highland Park, Mr. Washington?
I'm in Belleville now.
You're in Belleville now?
Yes, yes, Your Honor.
All right. So is there anything you'd like to say on your own behalf, Mr. Washington?
I want to say first, thank you to the court system for, allowing me to even speak on what's going on. I just want to say I was having a hard time paying, and it was like I finally get a job. I'm gonna just show through my actions. I'm on probation. I just show better than saying it, but I would say thank you for everything. I would never have to come through this court situation again, and can I just prove myself and go through the therapy and take it day by day, please.
Right, and Belleville is still, or you said Belleville, right?
Your Honor?
You said you live in Belleville?
I can't hear you, Your Honor.
What city did you say you live in?
I'm in Belleville right now.
And that's Wayne County, right?
Yes.
Right on the edge. Okay. All right. Okay. Thank you, Mr. Washington. So
yes,
in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence on the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. So I'm going to quash the bench warrant at this time, Mr. Washington. On file number 24-21810FH, it's a sentence of the court that you'll be placed on probation for a period of 2 years. You will pay $450 in court-appointed attorney fees, $100 crime victim rights fee, and $50 in state costs. You must obey and comply with all the terms of your probation, and you are to complete anger management and domestic violence programming, which will be set up through your Wayne County probation officer. We have a really wonderful program. What's that lady's name that does it here?
Sally.
Said, well, yeah, but that's a little far for you to drive. So you must enter and complete that program. on, let's see, yep, and then on count 2, assault with a dangerous weapon, felonious assault, which is the same file. You will pay also probation for a period of 2 years, $750 in court costs, $130 crime victim rights fee, $68 in state costs. There's a $30 per month supervision fee, 60, we have to put a tether on you. And you are not to have any contact with any of the victims on the domestic violence, either directly or through a third party. You can't have any type of weapon in your possession. There is a sentencing agreement to 6 months jail suspended. So I will order that 6 months in the Lenawee County Jail, and that will be suspended upon any violation. So that's that file. And they ran obviously concurrent. On file number 24-21741FH, sentence of court will be placed on probation for a period of 2 years. There is, all right, I'm gonna order $750 in court costs and $450 in attorney fees. Didn't Judge Pickard used to do something, if you paid it on one file, you didn't have to pay it on the other?
Yeah, he did that, yes.
Okay, so Mr. Washington, if you pay that off within the next 12 months on the first file, I'm gonna order you don't have to pay that on the second file, but if you don't, you're gonna have to pay it on both files, got it?
Yes, Your Honor.
All right, there's $130 crime victim rights fee, $68 in state costs. There's $1,000 in restitution, which is why I'm willing to do that for you. And, okay. It has, $68 in state costs and $60. I don't think,
68 state costs on each conviction.
I know on 7 it said 60, so I think that's a typo. On 24-21742FH, which is the R&O, you'll be placed on probation for a period of 2 years, pay $130 crime victim rights fee and $68 in state costs, $30 per month supervision fee, as I said before, $60 per month if we need a tether on you. So, Mr. Washington, you always come into court, you're very affable, you're very respectful, you're obviously, you know, highly intelligent and personable. You have a very long record.
Yeah.
And how old are you now?
34.
All right, so you're still young, but
Yes.
you're getting tired of this?
I've been tired of it. It's just I make the bad roast decisions when I love somebody hard. I just don't be want to let them go, and it caused me problems. And it's caused me problems to the point where like it's messing up like me trying to get a job or either me, my relationship with my kids. So yes, it took this much for me to really just I'm done with it. I just want some therapy and I'm just some help and I'm just done with it. I'm done with it.
Well, you need counseling because you can love somebody really hard and it be healthy, okay? So you need to learn how to do that, okay?
Right.
And you can learn how to do that. It's just kind of, I'm sure you were, you know, were you exposed to domestic violence as a child?
No. Probably just going through being in prison for like more than 10 years, and it was just growing up, you know, and I'm not like I said, I'm not a violent person. It's just that the moments where a person just stop thinking and then, you know, but I'm not a violent person. Like I prefer to talk it out or, you know, or go walk away or something like that. It's just the mistakes that I made cost me with the situation I'm in now. So it's like I said, I learned from it, and it's just, you know, I'll just get it. Yes.
All right. So I do want to make sure that they know I want to order an intensive domestic violence program. All right. So Mr. Washington, you can make those changes, and I wish you the best of luck. Is there anything, and these all run concurrent. Is there anything else, Mr. Stevenson?
No, Your Honor.
All right.
Hey,
So you do have.
Markeith, you're going to want to return that device. If you can do it today, do it today, because they are charging you every day that you have that, even if it's not turned on.
All right. And I'll say thank you too, man, for working with me. Appreciate it.
Welcome.
Okay, so Mr. Washington, let me double check if I have the right address in the file. Don't put it on the record, so hold on. Let me see here. Trying to find your address. Let's see here. What's your street name, Mr. Washington?
Cross.
Is that the address you have?
Yes, I'm not sure, but I may have the incorrect city.
City?
What city are you living in? Belleville?
Yeah.
So it's Belleville is your mailing address, right?
No, Cross is my mailing address. This is the city I'm in right now because the job I'm working at that I just got hired at. So this is the city I'm staying at right now, but this is not the address. I'm still be staying at the Cross Street. It's just this closer to the job that I'm working.
Okay, so here's the deal. As a term of probation, we got to know where you lay your head at night.
Yes,
And that's-
1165. Yeah, it's gonna be 1165 Cross Street.
Car, C-A-R-R, or Cross.
Cross. CROSS.
And that's Highland Park or Belleville?
No, that's Ypsilanti, Michigan.
Okay.
Yes,
All
right.
right. Okay. All right. So we are going to mail to you your notice of right to appellate review. You're going to get 3 copies for each file. Okay. And then separated with a paper clip will be 1 copy for each file that will be marked for you to initial and date in a self-addressed envelope. So you need to initial and date each copy, fold them up, put them back in that self-addressed envelope to me, and put them in the mailbox, okay? Because that's
Yes,
how I
ma'am.
know you received the paperwork. The other
Yes, ma'am.
copies are for you. And if you wish to appeal your sentence, you would fill out the information on those forms and mail it again to the address if you wish to appeal within 42 days, all right?
Yes, Sharon.
So you're gonna get that envelope from me. Make sure you do what you need to do on that and get it back
I
to
will.
me. You are going to need to report to probation here one time before we can do a transfer. So when do you want them to report?
This Tuesday, 9 a.m.
So we need you to come here Tuesday at 9 a.m. to report to the probation department because we have to put the paperwork in to transfer you to another county, all right?
Yes, Your Honor.
Okay, and then get your tether in today because otherwise you're paying a ton of money for that every day, all right?
Yes, Your Honor. So you gonna put the motion in for me to start the therapy?
It'll be a
Or-
term of your probation and then
Okay.
your probation officer will direct you where you should take that programming, okay?
All right. Thank you, Your Honor.
Okay, but if you Google something in your local area, there's like a lot of programming and group sessions you can go to that might be free too, all right?
Yes, Your Honor.
Do you go to church?
Yes.
Your pastor may offer services too.
All right. And I didn't think about it, but I will ask him.
Okay, all right. Good luck to you, sir. Thank you.
All right. Thank you. Have a good day.
You too. Bye-bye.
Bye.
So, it'll organize who I have next. Okay, Ms. Underwood, you got MDOC, I got Oliveras. So let's see, you need to talk to Oliveras. Mr. Oliveras, why don't you come up? What happens? I go on vacation and then I don't know what's up. Okay, this is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. I have Michael Dagger Margosian appearing on behalf of Mr. Oliveras, and I have Allison Arnold appearing on behalf of the people. Do you want MDOC brought up, Ms. Underwood?
Yes, Your Honor.
Okay. Yeah. All right. So, Mr. Oliveras, we are here today for sentencing. You are represented, as I said, by Mr. Dagger Margosian. Have you had a chance to talk to him and review the pre-sentence report?
Yeah, I spoke to him yesterday.
All right, scoot up to the microphone a little bit. You're kind of soft-spoken. Say it again.
Yes, I spoke to him yesterday on the phone.
I didn't call the case numbers. Oh, and it's file number 23-21358FH and 23-21499FH. All right, and when you reviewed it with them, did you have an opportunity to ask them any questions you might have?
Yeah, we got over everything.
Okay, and you're so soft-spoken. So, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
Yeah, he's done a great job throughout all my cases and that I've done.
Okay, Mr. Dagger Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
None to my knowledge at this time, Your Honor.
All right, before the court passes, are you on this file, Ms. Arnold, or no?
I'm not.
Okay, so, Mr. Dagger Margosian, we're here on one count of aggravated stalking and one count of attempted R&O. So, is there anything you'd like to say on behalf of your client?
Your Honor, I'm sorry, you say aggravated, it should be aggravated assault.
Didn't I say that? Assault. Aggravated assault?
Yeah, I thought I heard talking, but, thank you.
Maybe I said something else. I have an attempted R&O and an aggravated assault. Okay.
Your Honor, on behalf of Mr. Oliveris, in this matter, as indicated, we did go over the PSI. There are no additions, corrections, or deletions to be made. I did go over the recommendation with him, which is for the full jail amount. Mr. Oliveris' credit, he is here and is ready to obviously comply with whatever order this court gives. I do think it is important to recognize that in the face of this recommendation, again, he's here and is ready to fulfill whatever sentence this court gives him. What I will indicate on his behalf is that if the court looks at Mr. Oliveris's prior record, it's not an extended list either in amount of convictions or time span. Obviously, the time span is probably due to his age. He's young enough to where it wouldn't have gotten to that point. But again, it's misdemeanors, malicious use of telephone, failure to stop at the scene of a crash, retail fraud. So obviously, Mr. Oliveris is at a juncture in his life where he's going to have to make proper decisions. And of course, this sentence is one of the canons of sentencing is punishment. And so he's going to have to resolve that internally. I would indicate that I know the court knows how I feel about max out sentences. I think those should probably be reserved for the most offensive convictions plus defendant. I don't think Mr. Oliveris or these convictions rise to that level, but obviously it's the court's discretion. I would ask that if jail is imposed, that the court would construct it as such to make it commensurate with Mr. Oliveris. This court has full discretion, obviously, to make that call, but that's what I can offer.
Is there anybody here to speak on this case? A victim, I didn't know. Okay. All right, Mr. Oliveris, is there anything you want to say on your own behalf? And you gotta speak loud. It's the only time you can yell at me, all right?
No, ma'am. I'll lay it in your hands, whatever you want to do. I mean, I don't know if I'm asking for too much for my daughter here October 1st, so if I'm able to be out before then.
She's due? She's not Miss Gates' child, is it?
No.
Okay. 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 In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law and protection of society. So, Mr. Oliveris, the allegations in the police report are very, very, very severe regarding the assault. And you're lucky you're not being sentenced on a felony today. If you had pled to a felony, you would have been going to jail or prison. Do you understand that?
Yes, I understand.
Okay. You know, the minute you turned 18, you started picking up offenses. Your first one was a felony R&O that got reduced. No, it didn't get reduced. And then you got paid on that one, which is great. And then you had some other misdemeanors. You were successful on that, so that's good. You're not on probation for that one anymore. And then you started picking up these misdemeanors, and some of them are assaultive. And so I don't know if you have a juvenile record, but Mr. Oliveros, you have to make a choice. You're 22 now?
21.
21. So you're either gonna spend your life doing this. And Mr. Dagermark, I mean, your job security for defense attorneys, but we'd rather see you not come back here. So you need to grow up, make some better choices, and stay out of the criminal justice system. Otherwise, you're gonna end up in jail. I had a guy the other day that said he spent 12 years in jail of his life, in and out of jail. And I don't know, you're gonna miss the birth of your children, death of your family members. I mean, it's a hard road. So I'm gonna give you. Are you on probation in district court?
Yes, I am.
Who are you on probation with?
Elizabeth Westgate.
Okay, have you talked to her about what she's gonna do on these?
No, I haven't.
Okay.
I know I have fines and costs due, upcoming, but that was about it.
It's a sentence of the court, you'll serve 120 days in Lenawee County Jail. Let's see, an agreement regarding sentencing. You have 0 credit. Is that correct? You never spent any jail?
Should there be a day of the arrest? Did you go to jail?
Yeah.
A day?
Yeah, day. All right, so I'll give you 120 days in Lenawee County Jail. I'll give you credit for 1 day. And there is a, let me see here. Misdemeanor stuff. There is a $75 crime victim rights fee. And $50 state costs. Is state cost on both counts?
Yes.
So total of ×2. So there'll be a $75 crime victim rights fee and $100 state cost, $50 on each count. So Mr. Oliveros, we're going to take you into custody today. I did take your sentence down a little bit because of your age and lack of record, but I'm going to need you to sign your advice of rights first before we cuff you. So my bailiff has for you a notice of right to appellate review. You're going to initial and date 1 copy for our records. The other, there should be 2, right? So there are 2.
Yes.
Yeah. You're going to initial and date each copy. Just acknowledge you received the paperwork, and the other copies are for you. If you wish to appeal your sentence, you would fill out the information on the other forms and mail it to the address within 42 days. All right? You want to give that to your mom? Can he give that to his mom? Deputy.
Yes.
Thank you. Mr. Dagermark, can you go see if Rhonda can come back? Because if I lose her now, I'm gonna lose her for a while. Or I mean, I'll be busy doing something else for a while. Mr. Glazier, do you have Mr. Pointer with you?
I think he's in jail.
Oh, yeah. So Hi, this is Judge Anslone. How are you?
Yes, Judge, good. What can you do for us?
Doyle Pointer.
Pointer, got it.
Thank you. Bye.
Right.
Is she on the record?
Yeah, she should be going back.
Okay. What else are you having? What do you have?
Mr. Singleton?
Oh, Hassan. Anybody in here a civil attorney for a 9 o'clock
Yeah.
trial? Hey, this is Judge Anslone again. I also need Hassan Singleton. Either one will be fine.
Singleton, got it.
Thank you. Bye.
All right, bye.
So civil attorneys can go back to the jury room. And I'll be with you when I'll be with you. We'll be right with you, okay? All right. All right, who do I have from the jail? Mr. Reddick, can you go ahead and mute? I muted Jeff. Okay. So who do I have joining me from the jail?
Doyle Pointer.
All right, Mr. Pointer, let me grab your file. And Mr. Glazier. All right, this is in the matter of the people of the state of Michigan versus Doyle C. Pointer, file number 24-21811 FC. I have you.
Yes.
I have Allison Arnold appearing on behalf of the people and John Glazier appearing on behalf of Mr. Pointer. Do you have paperwork for me?
Judge, I do have a victim statement, impact statement from a Maya trout that we received this morning, and I did email it to Mr. Glazier's office.
All right, Mr. Glazier, did you receive that?
I have, Your Honor. I don't know if Mr. Pointer's seen it or wants to see it.
Well, I was gonna say, would you like a breakout room to review that with him real quick?
Sure.
All right, so Mr. Glazier and Mr. Pointer, I am going to put you in a breakout room. Go ahead and join that breakout room. So I have another gentleman joining me from the jail. What is your name, please?
Me,
Yep.
Hassan Singleton.
All right. Where did Michael?
Just.
Do you want to go grab? I got you. Okay. Miss Adams, could you text, or maybe Mr. Jagger Margosian to see if you can come back? Okay. Right, Mr. Bernstein, I was just trying to get MDOC out before I started that sentencing, because I don't want them to have to wait around all morning. So it'll just be a minute, Mr. Bernstein, all right? All right, so Mr. And, oh, well, never mind, I got Mr. Dagmar.
Can I speak with Mr. Singleton?
Yeah.
Thank you.
So, Mr. Singleton, your attorneys, do you want him back?
If the civil attorney put back there.
Oh, okay, that's fine. So, Mr. Singleton, your attorney is gonna zoom in and talk to you for a minute, all right?
Okay.
All right. So, Mr. Abro and Mr. Reddick, I don't see any other attorneys here on that one. So this is in the matter of Brittany Karn as personal representative for the estate of Cole Weber, deceased, versus Matt Coaster and Fremont Insurance, file number 24-7287NI, and Brandon Abro, P77606. Is that Abro or Abro?
Abro, Judge.
Abro. All right, and I have Attorney Matthew Reddig, P67545, appearing on behalf of defendant Coaster, and I have Christopher Petrick, and your P number is 76345. Are you appearing on behalf of Fremont?
I am, Your Honor.
Okay, so this is the date and time set for a civil pretrial conference. So starting with plaintiff's counsel, Mr. Abro, when can you file a, let's see, expert witness list? How long do you need to file that?
I think 90 days would be okay, Judge.
Okay, so hold on one second. All right, so Mr. Singleton, I am going to open up that breakout room and send a request to both you and Michael Dagger Margosian. And you're going to click on join. So
Okay.
let's see, where are you at? You're in jail Zoom 4. And Michael. All right, there you go. All right, Mr. Glazier and the other gentleman from the jail don't join. All right, so you said 60 days, Mr. Abro?
I have requested 90 days, Judge, if that's okay.
Okay, 90 days. So June. So let's go to September 20th. And then Mr. Reddig and Mr. Petrick, how long after that do you need to file your expert witness list?
I would say either 14 or 21 days, Your Honor.
Yeah, that's fine.
Okay, so how about, let's just go to October 18. All other lay witness lists will be due by October 18 of 24. So if we're mid-October, by the time we get expert witness lists completed, how long will you need for discovery after that? Because, you know, obviously you're not going to get a trial date to 2025, late 25. So if you want to go another 180 days after that, that's fine. If you want to do 120, so Mr. Abro?
I have 120, that's fine.
After October, so starting in October?
Correct.
Okay.
Yep.
All right, so that would end discovery. How about we do March 7? Is that all right, Mr. Abro?
That's perfect, Judge. Thank you.
Mr. Petrick?
That should be fine, Your Honor.
Mr. Reddig?
That works, yes.
All right. Okay, so that'll be 2025. So we do offer case evaluation quarterly. Most people do not use case evaluation anymore because of the changes in the law. So are you going to use facilitation, or would you like to avail yourself of case evaluation?
I'm happy with facilitation or case eval.
Okay, and do we need a deadline for facilitation?
I would say maybe a month after discovery ends.
Is that all right, everybody?
That works for me.
That should be fine.
All right, so I will say that you will facilitate by April 11. And make sure you schedule early. You know, they're always backed up. All right, and let's see, facilitation. All right, so we're gonna facilitate by April 11 and discovery ends by March 7 of 25. When do you want a hard date for dispositive motions? Do you want right after discovery ends or after facilitation?
For the filed by date or the heard by date, Your Honor?
Both. I heard by.
I would prefer before facilitation, just so we're not at facilitation for no reason.
Can we do a filed by date the week before the facilitation deadline, Your Honor?
And then have a heard by date later?
By the end of the month, perhaps?
So filed by, you're saying filed by like April 4, but heard by April 25?
That would be fine with me, Your Honor.
Mr. Abro, Mr. Reddick.
That works.
That's fine.
All right. I'm gonna write that in. Okay. All right, so I have filled out a pretrial scheduling order. So that'll take us into May 9th for a settlement conference at 9 a.m. and that is in person. So, yeah, I'm not here.
You are not here that day, sorry.
Nice. How about, let's go to May 16. Am I here that day?
You are, yes.
Okay, so I'm gonna set it over to May 16th at 9 a.m. That will be in person. So all parties with settlement authority and counsel must be in person. I might keep you here for a half hour. I could keep you here for an hour. I could keep you here all day because I don't golf. And if I think I can get you guys to settle, I will keep you here all day. All right, so I filled out a scheduling order and we will mail a copy out to everybody. Is there anything else we need to address?
Your Honor, I'm sorry, go ahead, Brandon, I apologize.
So I was gonna ask, I just noticed that there was co-plaintiff in this one, but I wasn't sure if the motion to intervene was granted or not.
I don't know. Was it heard?
There's a motion that was filed. I think it's pending, Your Honor. And there's a pretrial in that matter later this month.
Oh, okay.
Well, then it hasn't been granted yet because I haven't heard it. So I guess they'll just be stuck with the dates, right?
Yep.
Yeah, they're far enough out. Shouldn't be an issue.
Yeah.
There's
right.
also another decedent who is potentially a claimant, at least with respect to my client, who has not been added or filed. There are at least two other plaintiffs, individuals who passed away in this accident.
So what I would say is these aren't hard dates. So if you need to add parties and adjourn dates and counsel comes on, you can always do that by stipulation. I don't need you to file a motion if all the parties agree. Just do it by stipulation to move all these dates and get a final settlement conference from my staff. All right?
Thank you, Judge.
Very good, Your Honor. Thank you.
All right. Thank you all. Have a good day.
You as well.
Thank you. All right. So, Miss Underwood, let's take your client. And then let me get him. You want to step up there with Miss Underwood? All right, Mr. Wilson. All right, so this is in the matter of the people of the state of Michigan versus Frederick Dwayne Wilson, file number 23-21557FH. I have Rhonda Underwood appearing on behalf of Mr. Wilson. Mr. Wilson is here in person. I have Allison Arnold here on behalf of the people, but I don't think she's on this file. So, Mr. Wilson, did you get a chance to review the pre-sentence report with Ms. Underwood?
Yes.
Okay, scoot up a little bit so you can talk into the microphone. Thank you. And you had a chance to ask her any questions you might have?
Yeah.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you? All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, on the front page, I don't believe it indicates that Mr. Wilson has a psychiatric history. Mr. Wilson does and takes medication.
Okay, Miss Holly, oh, there she is, Miss Holly, I think that's pretty well documented, it's probably a typo.
Probably, no, it just, our new format won't let us, it won't pop up, even if we put it in the.
So can I white it out and write it in?
Yeah,
Okay,
that'd be great.
all right, so, okay, so I've written that in, okay. Ms. Underwood, anything else you wish to explain or challenge?
No, Your Honor.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not, Your Honor.
All right. The probation department has calculated the minimum sentencing guidelines to be 5 to 17. Do you agree with that calculation of guidelines?
The only thing I would say, Your Honor, is on number 3. I don't believe there was actual injury. This was a spitting incident, and I don't believe there was actual injury.
Okay, so OB3 is physical injury to a victim. Okay, and was the correction officer actually touched by the spit?
Yes.
Okay, and so did he have to seek treatment because of that?
I'm sure he did. It's totally sure.
Did you get fingerprinted? Have you been fingerprinted? Okay.
Did they take you this morning to get your fingerprints?
Yeah. Okay.
Your Honor, he's indicating to me that they.
What did they score? How many points? Yeah. All right. Okay, is there any information about communicable diseases? Hepatitis, HIV, anything like that?
The police report is very minimal. I asked for a victim statement, but I didn't get one of those.
Okay, all right, so, but for that, I mean, if there was an indication of any of that, I think it was properly scored, but in this case, I will mark it at 0. But it doesn't change the guidelines, correct?
I'm sorry?
If I scored at 0, does it change the guidelines?
I don't think so.
I don't think so. So, okay, so I'll score it at 0 because we have no statement regarding whether there was any communicable diseases or injury. Okay, so before the court passes sentence, is there anything you want to say on behalf of him?
Your Honor, just briefly, as you know, I see a lot of these cases, and my frustration is that when we see these men in court, they're medicated, they're polite, they are able to be here. And I think And I do not, and Mr. Wilson does not condone his conduct that led him here, Your Honor. He understands. When I'm talking to him today, he understands that that was unacceptable, and he's sorry for what he did. I would hope, and I know the court has cops to the low end of the guidelines on this matter, Your Honor. And we would ask the court to enter that as an appropriate sentence.
Judge, I'm sorry, I do have a statement from the victim.
Oh, is it in here?
I'm sure I set it down, but can I approach?
Yeah. Did you get that as part of your PSI?
The victim's impact statement?
Yeah.
Yes, I did get it.
It says he went to the hospital.
Okay. So there's a statement that says the nature and extent of my injury was saliva from his mouth into the right eye area and the right chin. Talks about psychological and emotional harm. The fact that it was first time this officer had ever been assaulted in the prison system. Okay, so the hardest part was calling my wife to let her know I was heading to the hospital per work orders because I'd been assaulted by a prisoner. I think the hardest part because my wife would want to hear that, wouldn't want to hear that as a husband and father. Okay. She immediately panicked. I was able to give her the full details. I had to sit in the hospital for roughly 3 hours and do multiple eye flushes, eye drops, and primary blood work done to detect. So I'm sorry, I'm gonna take that back. I am gonna score OB3 at 5 points. Thank you, Ms. Ellie.
That's fine.
Okay,
We understand.
so we'll leave that at 5 points. Okay, so anything else? Continue, Ms. Underwood.
And we would just ask that the court sentence Mr. Wilson to 5 to 30 months consecutive in the Michigan Department of Corrections pursuant to the agreement.
Mr. Wilson, is there anything you want to say on your own behalf? No? Okay. Mr. Wilson, as I look through your record, you're just serving time on assault of prison guards now, right? Are you still have like, I see a concealed possession, assault of a prison guard, assault of a prison guard, assault of a prison employee. You got 4 to 15 on, are you still serving the 4 to 15?
Yes.
Okay, because that's an offense date of 2010. Okay, all right. So, Mr. Wilson, anything else you want to say at all?
Sorry, and just, and it was right. They take it free, so I can see parole board. Just been holding off. Right.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law and protection of society. Sir, even if you max out on your CSC and larceny charge, you're stacking up these assault of a prison employee cases. You understand? So every time you get one, it stacks because you don't get credit, and you got like 4. I think this will be your 5th one. So even if you max out on that other case, you're going to serve each one of those individually, and they stack. So I can't imagine what it's like working at a prison. I can't imagine what it would be like being a prisoner, but I have to think it would be hard for everybody. But you have to stop getting in trouble so that eventually you can go home. All right? So it's a sentence of the court that you will serve 5 months to, it's 30 months, right? 5 months to 30 months with the Michigan Department of Corrections. I can't give you any credit for time served because it stacks. So these are consecutive. This would be consecutive to your other sentencings, okay? And there's $130 crime victim rights fee and $68 in state costs. And you do have the right to appeal the sentence. So my bailiff's gonna hand down to you your notice of right to appellate review. I need you to initial and date the top copy for my records to note that you received it. Ms. Underwood, will you move your iPad so you can sign that? And the other 2 copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Mr. Glazier, I'll take you next. You're all set, okay? Good luck to you. All right, so, Mr. Pointer, back on the record in the matter of the people of the state of Michigan versus Doyle C. Pointer, file number 24-21811 FC. I have John Glazier appearing on behalf of Mr. Pointer. I have Allison Arnold here on behalf of the people, and Mr. Pointer is joining us from the Lenawee County Jail. Mr. Glazier, you had a moment to review the victim impact statement with Mr. Pointer.
I did, Your Honor.
All right. So Mr. Glazier, do you wish to explain, or Mr. Pointer, you've had an opportunity to speak with your attorney and review the pre-sentence report as well as the victim impact statement?
Yes, ma'am.
Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, I am.
All right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. Ms. Arnold, do you?
No, thank you.
All right, Mr. Glazier, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
I don't think my client, I guess he's got one prior misdemeanor, so not that I'm aware of, Your Honor.
Okay. The probation department has calculated the minimum sentencing guidelines to be 12 to 24 months. Do you agree with that computation of guidelines?
Yes, I do, Your Honor.
Ms. Arnold?
We do.
All right. There is an agreement that he would be sentenced to 1 year in jail and 5 years probation. Ms. Arnold, is there anything you'd like to say on behalf of the people?
No, Your Honor, we do have Erica McCurdy who's gonna speak on behalf of the victim of my trial.
Okay. Do you want to come on up? So why don't you just come right up to the podium?
She's gonna read Ms. Trout's victim impact statement into the record.
Okay, so first I need your full name, please.
Erica Rochelle McCurdy.
Okay, is it MC Big C ARTY?
URDY.
URDY, okay. All right, you may, and the microphone's there, you can adjust it a little bit. And if you can speak loud enough, because this is recorded, are we able to get a copy of that statement?
Is
that the one you already gave us?
Yeah.
Okay, good. All right, go ahead.
So you have no idea how much your choices impacted my life or how difficult you have made my life for me. You don't know what it's like to wake up one day and not recognize the body that you are in or the person you were before it happened. For the past 15 years, I've had more I've had many different ways to cope with the pain that you brought on to me. I used to feel nothing but endless amounts of pain, sadness, and anger. I spent my teenage years angry. I did a lot of counseling and therapy. I've had a lot of time to think about the things that you've done. I was so angry at what you did to me. I couldn't understand why someone I trusted and felt safe with would be so cruel. Did you think about how much it would affect my life? Did you think about anyone's lives, or did you think this was something that you could easily just forget? Because it wasn't you who was being taken advantage of. When I found out the news that you had been arrested, I finally felt the relief that younger me should have felt a long time ago. And I still feel sorry for that little girl that's hurting, that didn't get to see you sitting where you are today. Even though you had gotten away with it for as long as you did, you won't any longer. And I will no longer live with this anger you brought on to me. You will no longer be the baggage that I carry, because you don't get to be a part of my story. You, or who you are and what you did to me, does not define who I am. You can deny the things you did, but you and I will always know the truth, and that's enough for me. Now that you get to have time to sit and think, I hope you think about not only my life you affected, but everyone in my family whom you affected as well. I hope the guilt of what you did eats you alive. I would say I forgive you, but I've already spent the better part of my life pleasing people who have hurt me. So unfortunately, you don't get to be spared the grace of forgiveness, because people like you don't deserve grace or forgiveness. I'm glad that you're sitting exactly where you're at, so get comfortable, because it's gonna be a while. You can't hurt me and you can't hurt anyone else. Enjoy your stay.
Anyone else?
Thank you, Jeff.
All right, Ms. Arnold, anything you want to say on behalf of the people?
No, thank you.
All right, Mr. Glazier, anything you want to say on behalf of your client?
Your Honor, my client pled no contest. We don't really wish to address the issues here. But I did have a comment on the recommendation. It says it may not leave the state without consent of this court. My client is a resident of Florida, and I think he was actually brought up from Florida on this matter. So we'd ask the
Mr.
court.
Jones. All right, Mr. Jones, would you like to weigh in on that?
Judge, we'll take care of the transfer once he's sentenced. He gets closer to release from jail.
All right. Mr. Jones stated that because he is a Florida resident, once he gets closer to his out date, they will take care of the transfer.
Okay, so that would be taken out of the sentence then?
Well, that's the permission he would get, would be to transfer. So, but until he gets that permission to transfer, he can't leave the state.
It's still gonna be required of the $200 transfer.
Yeah, he has to pay a $200 transfer fee. So until that's processed and his permission is granted to leave the state,
all right,
it should be fairly quickly.
Okay, that's fine.
Okay, anything else, Mr. Glazier?
No, Your Honor.
Mr. Pointer, anything you'd like to say on your own behalf?
No, ma'am.
All right, it's sent to the court, or I'm sorry. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence, and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. Sentence of the court that you'll be placed on probation for a period of 5 years. You will serve 1 year in the Lenawee County Jail. I will give you credit for 146 days already served. You must pay a $750 court cost, $130 crime victim rights fee, $68 in state costs, $450 attorney fee, $60 DNA fee, $30 per month supervision fee, and $60 if an electronic tether is ordered. You are to have no contact with the victim in this matter, directly or indirectly. You will be required to be on the Michigan Sex Offender Registry for life. Terms of probation will involve not to violate any criminal law, complete sexual abuse prevention programming and treatment, register in the state of Michigan, and if you're required to transfer that to the state of Ohio or Florida, you need to do that as well. Can't leave the state without consent of the court until that transfer is done. You're not to use or possess alcohol or any illegal controlled substances. Test as required, report as required, not to engage in any assaultive, abusive, threatening, or intimidating behavior, not to use any weapon or any item as a weapon, consent to search and seizure of your personal property, your car, your phone, your computer, anything of that nature. Anything else, Mr. Jones?
That's it, Judge, thank you.
All right, so you do have a right to appeal this sentence, Mr. Pointer. We're going to hand to the jail, we'll get to the jail for you to initial and date one copy of the notice of right to appellate review. Just initial and date that one copy. The other two copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right, we're all set. So thank you, Mr. Pointer. Thank you so much for speaking today. Thank you. All right, you're all set, Mr. Pointer.
Thank you, Your Honor. That's
Do
all
you
I
have a
have.
copy of that, Joanne? Joanne, do you want that?
Yes, please. I'm sorry, Judge. I'm sorry. Yes, thank you.
Why sorry?
I
I stole it from you. Okay. All right, Mr. Singleton. Matter of the people of the state of Michigan, and we're ready for Mr. Thomas. Is Mr. Thomas here? He's in jail.
Yeah, Zoom.
Oh, I thought he's supposed to be in person.
We got Zoom here. We never brought him in.
It says in person.
We got Zoom here.
No.
Your
the
Honor?
Attorney's, he's in jail in person, see? Yes.
I had emailed the court last week and said that Mr. Toms was okay to be sentenced by Zoom.
Oh, the jail list him has him in person. Becky, can you call the jail and get him, please? Okay. All right. So this is in the matter of the people of the state of Michigan versus Hassan Singleton. This is file number 24-21731. FH. I have Michael Dagger Margosian appearing on behalf of Mr. Singleton, and I have Allison Arnold appearing on behalf of the people. This is the date and time set for sentencing. Mr. Singleton, did you have a chance to talk to Mr. Dagger Margosian?
Yes, ma'am, I did.
I'm sorry, can you speak up a little bit for me?
Yes, ma'am, I did.
Excellent. Are you satisfied with Mr. Dagger Margosian as your attorney?
Yes,
And the
ma'am.
advice that he's given you, all right? Mr. Singleton and Mr. Dagger Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, before we get to that, I'm wondering if we could approach briefly.
Okay, who's we?
I guess maybe the three of us.
Okay, all right, so hold on. So, Mr. Singleton, I'm just gonna ask that you bear with me for just a minute. I'm gonna pass your case and do another case, and while I'm waiting for the jail on that case, I'm gonna step off the bench.
Okay.
For about 2 minutes.
All right.
I get a schedule from Becky for the next day, so that then you get a jail, with your jail thing, so
Yeah.
there's like two different schedules. So they, a lot of times they're not gonna go together, I guess.
Right.
So, all right, I just didn't know, because I don't get a jail,
Oh, you don't get it?
so I just, but I just get the schedule. what
Sure.
Becky gives me, that's what I would get.
Oh, gotcha. Okay. I can make a copy in the morning.
Yeah.
Okay.
Sure. Because it would be confusing.
Mhm.
Mr. Bernstein had cleaned that up, but-
Yeah. Yeah.
So Becky got the right information.
Right. Yeah.
Rise.
So, Mr. Bernstein. All right, we have Mr. Toms. Okay, this is in the matter of the people of the state of Michigan versus Douglas Henry Toms. File number 23-21221 FC. I have Allison Arnold appearing on behalf of the people, and I have Samuel Bernstein appearing on behalf of Mr. Toms. This is the date and time set for sentencing in this matter. So.
Your Honor, before we
This-
begin.
Yes, sir.
I just need to tell the court, I've met with Mr. Toms several times since the trial. This last Wednesday, he did tell me that he wanted to fire me and that his family was in the process of hiring a different counsel. And so I felt I needed to tell the court that because he was pretty clear in his wishes to me, and I'm concerned about going forward, given that I understand there's probably a victim impact statement today. I'm not trying to eliminate the time for that or anything, but I needed to relay what Mr. Toms told me.
All right, so Mr. Toms, have you had an opportunity to read and review the pre-sentence report?
Yes.
Mr. Toms, did you have an opportunity to meet with Mr. Bernstein to review that pre-sentence report?
Yes.
Okay, and you're at this time, is it correct that you wish to fire Mr. Bernstein and retain different counsel for sentencing?
Yes, and I'd like to get an adjournment to have enough time to do that.
Okay, and Ms. Arnold,
Judge,
I don't think I have much choice.
no, I don't think so.
Okay. All right, so I can adjourn this 30 days for you to retain counsel for sentencing.
Thank you.
All right, Ms. Adams, I need a date for sentencing about 30 days out.
Tuesday, July 30th at 8 a.m.
Is that day good for everybody?
It is, Your Honor.
All right, so Mr. Toms, I will adjourn this to July 30th at 8 a.m. Mr. Toms, do you want me to release Mr. Bernstein as your attorney?
Yes.
All right, so Mr. Bernstein, I will release you as counsel on this case. Mr. Toms, if you do not retain counsel, because obviously if you can retain counsel, you don't qualify for court appointed, you will have to, understand that we're moving to sentencing on that day.
Okay.
All right, thank you.
Thank you, Your Honor.
Am I done?
You're all set, thank you. I'm sorry, Ms. Arnold. All right. So, Ms. Arnold, let's see here. Wilson. Miss Underwood, are you here on a case?
I'm just waiting for Sprusser, Your Honor.
Oh, okay. Well, I don't know when that's gonna be. All right, so Mr. Dagger Margosian, do you want a moment to talk to Miss Arnold?
Sure. Yeah.
Judge, I sent you a chat message.
Convicted under a statute of another state relating to narcotic drugs, cocaine, marijuana, or stimulant depressant, or hallucinogenic drug.
I understand. I think there's a lot of things pushing back on that. And I think-
All right, so Brendan Dennis, are you here? Let me find it here. So,
Mayor Adam Pelfrey versus State Farm, Your Honor. And so is Mr. Tantello.
all right, so I have, well, it doesn't look like I have everybody. So in the matter of Adam Pelfrey versus Buffy Hunter, Deanne Overy, and State Farm Mutual Automobile Insurance.
You don't, Judge. You're right. You don't have the third-party defendant's attorney. I'd almost forgotten about him myself. So,
well, if they don't show up, I proceed without them. So not my, so file number 23-7080 NI. I'm Brendan R. Dennis, P73192, appearing on behalf of defendant State Farm. And Mr. Tantello, you are here on behalf of who?
Representing Adam Pelfrey.
Okay, the plaintiff. So we do not have anyone appearing on behalf of defendants Hunter and Overy, but
They're outside in the hallway.
is the attorney?
No, he and Buffy Joe are, we don't know where the attorney went.
Okay. You can go get him and bring him in if you want. Evidently, there's a bunch of people in the hall.
I'll get him right now.
Okay. So, Miss Adams, it says in person on this hearing.
Let's see what the ROA says.
All right, so I have a bunch of the parties in the courtroom, but I do not have the attorney for defendants Hunter and Overy present. So so all of you are represented by Mr. Scanlon or Mr. Musson? Okay. All right, have you heard from him?
I was just, on the phone with this paralegal and I had to hung up because it comes to court because I understand you're not supposed to vote not.
Okay, and what is your name?
My name is Deanne Folger.
Okay.
We're honking up.
Thank you for calling the Law Office of LLC. We appreciate your call. Be with you. Thank you.
Law office.
Hi, this is Judge Anna Marie Anzalone, and I'm calling from the 39th Circuit Courtroom. I had a 9 a.m. pretrial this morning on Adam Pelfrey versus Buffy Hunter, Deanne Overy, and State Farm Mutual Automobile Insurance Company. There was a stipend order signed by all the parties to adjourn it to today, and I do not have Mr. Scanlon or Mr. Musson.
So I just got off the phone with Gerard, and he's claiming he didn't know anything about this, and he's on the way with doctors, he wants to know if he can appear by Zoom. You want his cell phone number?
No, I'm not gonna call him, but he can appear via Zoom. The other attorneys have.
Okay.
But he signed a stipend order to agree to move it to today, so.
I will tell him.
All right.
Okay, is there a Zoom ID?
I'm sorry?
Is there a Zoom ID? Do you have that?
There is. I'm gonna transfer you to my assistant because I don't want it put out on YouTube. So I'm gonna, Miss Adams, you're not on the phone, are you?
No, I'm not, Judge.
I'm gonna transfer you to my assistant and she'll give you the Zoom number, all right?
All right, thank you, I appreciate you.
Thank you. Did I transfer it, Becky? Did I do it right?
Yes.
Do you two want to approach? Yeah.
No.
Oh, not you guys, no. Okay, I'll do it right now.
So, I'm sorry, Al, so. Are you good with the? So, counts as that. It doesn't, yeah, that's fine.
All right. Okay, so Mr. Singleton, we are back to you. So on the record in the matter of the people of the state of Michigan versus Hassan Abdul Singleton, file number 24-21731 FH, Michael Dagger Margosian and Allison Arnold. So we've had an opportunity off the record to do some research. So there was an offer that if he was eligible for 7411, the court has had some discussions with counsel about it. In light of the fact that Michigan law being what it is and that the prior conviction was a Georgia conviction, I do feel like if it had been a Michigan conviction, he would be eligible. So I'm going to rule that he's eligible and it's in his best interest and for the point of justice. So I will honor that agreement. So Mr. Dagger Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor, thank you.
Ms. Arnold?
No.
All right, the guidelines, as I said, I think I said, I don't remember what I said at this point, were 0 to 9. Do you agree with that calculation guidelines?
I do, Your Honor.
Is there anything you want to say on behalf of the people before the court passes the sentence, Ms. Arnold?
No, thank you.
Mr. Dagger Margosian?
Your Honor, I'll keep it brief. Obviously, the sentence agreement has already been established, as the court's already indicated that it's made its ruling. Mr. Singleton, I know he does want to address the court as well, but on his behalf, I'll indicate that he has gone quite a while without being involved with the criminal justice system. After today, he's going to not be involved any further. He's gonna move back to Detroit. He's gonna get a job, take care of his kid. I would just ask the court to follow the recommendation of 55 days jail with 55 days credit, as well as the deferred sentence under 7411, as the court indicated, it's what will be best for him. So that's all I have for the court.
All right, Mr. Singleton, anything you want to say on your own behalf?
No.
No?
No.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and others, the potential for reformation, vindication of law, and protection of society. So, Mr. Singleton, you have a child now, right?
Yes,
Boy or girl?
2 boys.
Okay. And Mr. Singleton, do you have a good relationship with your parents?
Like, I have a good relationship with my grandma, my mother, and my dad. They trying to come around, but they still distant. But I'm trying to build a better relationship with them, and I won't stop that. I'm gonna keep on trying to get them to come along, which I'm gonna try my best to keep on building a better relationship with them.
Okay. So, Mr. Singleton, you're a very young man. You made some mistakes. You don't have a huge list of mistakes, but you've made some mistakes. You know, this is the time to be the parent to your kids that you want to be. You know,
Yeah,
you
can
don't
I say
want
one
them.
thing? I didn't mean to cut you off, but I tried to write you a letter when I was in there. But I do appreciate you sitting me down, because that's something my grandma was getting too old to do. And that's something my parents wasn't around to do, because I was like jumping off the edge, doing something that my grandma did not want me to do, and something my friends didn't sit me down to do. Like, some of my friends didn't even come to me and approach me like, you doing something that you shouldn't be doing. You know, you should go home, take care of your grandma, you should take care of your little brother. Because I just missed my brother graduation. I wasn't around to change my son diapers. I wasn't around to even look at my niece and take her to cheerleader practice. Like, my friends wasn't even real enough to do that. But you looked me in my eyes and you said, you know what? To get you off these drugs, and I know that's not true, I'm gonna sit you in there for that amount of time, and I'm gonna get your head back right. So I think you deserve that, and I appreciate you for doing that, and I want to thank you for that.
Well, I appreciate that you say these things, because to me, it gives me hope that you will listen to your friends and your grandma and make better choices and, you know, be the parent you want to be for your kids and family, for your family. All right?
Yeah, that's what I would be doing.
All right. Well, it's sentence of court. I'm going to give you credit for time served of 55 days. I'm going to sentence you under the 7411 statute, which means this won't show on your record. And then you do have to pay $130 and $68. So $130 crime victim right fee and $68 in state costs. You can mail, you know, a money order, whatever it is from Detroit. You can make a ride down and make that payment, but I'm not going to put you on probation, but I wish you the best of luck. I want you to succeed. All right, Mr. Singleton?
Okay, I'll be taking therapy. I'll be taking classes, like going to the library by myself to read books and training myself. I'll be going on jogs. Like, I'm gonna take a pattern at a time. I won't be jumping off the board, like trying to do multiple things, because I know I'm not caught up like that yet. I'm gonna just do one thing at a time as a pattern.
Well, and I'm glad to hear that. And you've got some of the most beautiful libraries in Detroit. Some of my favorite libraries are there. So, all right, I wish you the best of luck. Now, you do have the right to appeal this sentence, and we're going to send over to the jail 3 copies of your notice of right to appellate review, initial and date, 1 copy. That's going to come back to me to show that you received your paperwork. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay, thank you.
All right, good luck to you. Thank you.
I'm sorry, I actually think an outstanding contempt, if that is the case, could that just?
I'll dismiss any contempt of court there might be. All right, thank you. Okay, so, all right, so I have everybody now. So I have Mr. Scanlon, Mr. Dennis, and I have Mr. Hello. All All right, so this is the date and time set for a pretrial conference in this matter. There's been a couple stipend orders. The last stipend order that was presented set the pretrial for today. It did set it. It did not state in person, but that's okay. So, in terms of expert witness lists, Mr. Tantalo, how long do you need to file an expert witness list?
Judge, at this point, I would say, excuse me, one moment. In terms of setting a deadline to file a expert witness list, I would say less than 60 days.
So how about August 23rd? You will file that by?
That's fine.
All right, and then Mr. Dennis, how long after that to file your expert witness list?
I probably, within that, Your Honor, probably only need a couple of weeks. We've already disclosed our experts and previously filed witness lists, but we can certainly update them if need be at that time.
Okay, and then, so how about September 13? Would that work for you, Mr. Scanlon?
Yes, it would, Your Honor.
Okay, and then lay witnesses by September 13 of 24. So if expert witness lists are filed by and all other by September 13, how long after that do you want discovery to extend, Mr. Tantalo?
Judge, I don't believe that we need discovery for too much longer after that. Perhaps another 30 days.
Mr. Dennis, would you agree?
Yeah, that's actually fine, Your Honor. The parties have been working together prior to this conference to get some discovery done already. So yeah, I think another 30 days at that point would be fine.
Mr. Scanlon, are you okay with that?
Yes, I am, Your Honor.
All right, so that will take us to like October 18. Okay, and I don't. So was a jury trial requested in this? Jury fees paid?
Yes, Your Honor.
Okay, I don't have that on my file. Okay, so what I will tell you is I'm probably not going to get you, you're not going to be able to get a trial date until next year. So if you need more time for discovery, that's fine. It's just my trial docket is backed up. So we're probably looking at early 25 for a trial date.
Okay, Your Honor.
That's fine.
Does anybody want an extra time for discovery? No?
No, I think that's fine.
Yeah, we can let the court, we'll be happy to let the court know if we need some additional time, Your Honor, but I don't suspect
That's fine. Okay, so we do offer case evaluation quarterly with the changes in the law. Nobody uses it anymore, but we do offer, or you can also choose facilitation. So do the parties wish to facilitate or to use case evaluation?
Plaintiff's preference would be facilitation.
Yeah.
Okay, and when would you like a deadline for facilitation?
So maybe within, when did you say the discovery cutoff was, Your Honor? I apologize.
October 18.
Probably be within 60 days of cutoff of discovery.
So that would take us like right before Christmas. Is that all right?
That's fine.
That'd be fine.
It's all right with the defense. Yes, Your Honor.
Okay, all right. So why don't we do the facilitation deadline by December 20th?
Okay.
All right, let me put that in here. All right, so then dispositive motions, I need a filed and a heard by date. Do you want it before facilitation or after?
After.
After.
Maybe after, but
Okay, so why don't we say, Ms. Adams, am I here February 14th? Would that be all right? 2 months, 60 days after?
Yes,
Ms. Adams?
Look, Judge. Yes, you are.
Right, so we will set that for Valentine's Day of 2025. And that's filed and heard by. All right, so I'm going to set a final settlement conference then for February 14th at 9 a.m. Now, gentlemen, I know this one wasn't set in person because it was a pre-trial, and that's fine, but all final settlement conferences are in person. I might keep you a half hour. I might keep you an hour. If I think that I can get you to settle, I've kept people here all day long. So anyone with settlement authority plus the attorneys must be present in person. So I don't have any objection to stipulation and orders to adjourn. I don't require attorneys to file a motion. If you guys all agree to adjourn dates, that's absolutely fine with me. Just make sure you remember that my final settlement conference is always in person, okay?
Understood.
Thank you, Your Honor.
All right. Anything else we need to add?
Not from State Farm, no.
No, Your Honor.
All right. Okay, so we'll see you all back. Good luck. Thank you.
Thank you,
Thank you,
Your
Judge.
Honor.
We'll get a copy of this order in the mail, Your Honor.
Yep, it's gonna come in the mail.
Great, thank you.
Thank you.
Thank you, Your Honor.
Thank you. All right, you guys are all set. All right.
Are we done?
You are all done.
Okay.
All right, thank you.
Is there any chance that we can change it February 14th date?
You are not required, or no, probably not. Are you gonna be out of town?
I live in Nevada. It was very
You
hard
can-
for me to be here, but February 14th is the day my dad died.
So are you the one with settlement authority?
I don't know what that means.
So are you a party?
Yes,
Okay, are you guys parties?
yes.
You're all equal parties together or the same?
Well, I'm a witness to what happened.
Okay, well, no, okay, so,
We should just deal with our lawyer to change
Yeah.
that date.
yeah,
All right,
I mean, they may give you a special reason not to appear via Zoom or something. Okay, you too, thank you.
Thank you very much.
Thank you. You have me worried, Mr. Brooks, but you're a half hour early, so. All right, so Milliman is off. I got Mr. Noe and Mr. Jackson in back. So I'm gonna go talk to them. All right. Oh, no, I still have Spresser. Is that why you're waiting, Mr. Vasquez?
Yes, it is.
Hi, this is Judge Ann Simone again. I have a pickup on Joseph Spresser. Is he upstairs or downstairs?
She's downstairs.
All right, do you want me to call down there?
Yeah,
Okay, thanks, bye.
thank you, bye-bye.
Hey, Jake, you can just zoom in. I know you watch me on YouTube. No, I don't. Thank you. Jack, 2, 3, 4, 6.
Horry County Jail.
Hey, this is Judge Ann Simone again. I am ready to see Joseph Spresser. He's a pickup from the court show cause.
Holding 3, got it.
All right, thank you.
All right.
Bye. Mr. Brooks, I'm just doing a child interview though, right?
I'm a glorified babysitter here today.
You're just a babysitter?
Yep. I have no positive or negative input to give you.
Right, but you didn't have to be here.
I know, but I
Okay,
told my client I'd be here.
okay. Because I'm not gonna talk to you,
You're doing that right now.
not about the case.
My wife said I have to behave.
I think your wife just sends you out so she gets some peace and quiet.
Well, she tends to think that when I'm in front of you, I misbehave, so I kind of watch it.
Well, that's because I text her and say you misbehaved today. I have all the wives' numbers. That's how we keep you guys in line. All right, Mr. Espresser, can you hear me?
Yes, ma'am.
All right, this is in the matter of Lisa Leora Kupshaw versus Joseph Paul Stresser, file number 2007-32101DS. So Mr. Stresser, we are here on two things, a failure to pay child support and a failure to appear. So it states here you're ordered to pay $202 a month in child support. And you have an arrearage of $5,510.19. The last time we were here, I ordered you to pay $500 by June 3rd of 24. And you failed to appear. You did make a payment in December of 23 in the amount of $500. And we've had no payments since then. Is that correct, Mr. Vasquez?
That's correct, Your Honor.
All right, so Mr. Spresser, you know, I try to work with people and I do adjourn things out, trying to get payments. So, Mr. Spresser, the contempt court for failure to pay child support can carry up to 90 days in jail. And the contempt court for failure to appear on June 3rd of 24 can carry up to 93 days in jail. And I can actually stack those if I wanted to. So Ms. Underwood is here today. Did you represent Mr. Spresser previously, Ms. Underwood?
I'm not sure, Your Honor.
All right, Mr. Spresser, you have the right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes, ma'am.
Okay, so I am going to appoint Ms. Underwood to represent you. And I am going to put both of you in a breakout room. Let me find. Go ahead and join that breakout room. Ms. Adams, I'm just gonna print off a bunch of search warrants on your computer or your printer.
Okay.
Hello.
She stepped off for a minute, Rhonda.
All right, Ms. Underwood, let me close the breakout room. Mr. Noe and Mr. Jackson told me that they think Miss Adams punishing me for leaving for so long by this
What?
morning's nothing. All right, so Miss Underwood, have you spoke to Mr. Spresser?
I've spoken
Rhonda,
with
Miss
Mr.
Underwood, have
Spresser.
you? Okay, is he eligible for court-appointed counsel?
I believe he would be, Your Honor.
Okay, so Miss Underwood, how would you like to proceed today on behalf of Mr. Spresser?
At this time, we would like to plead Mr. Spresser not guilty, Your Honor, and ask the court. Mr. Spresser has recently gotten work, Your Honor. He's doing landscaping and building retaining walls for a gentleman. And he's also done some tattooing. He should be able to make a payment next week, Your Honor. So we would ask the court to set this out to a week from Monday, Your Honor. And Mr. Spresser will pay $200 by next Friday. If he does not, Your Honor, Mr. Spresser has an address, Your Honor, and I'm sure he can be picked up.
Okay, all right, I'll enter a plea of not guilty on behalf of Mr. Spresser. But Ms. Underwood, I've released him over and over and over again, and he doesn't make the payments he promises to make. So, Ms. Adams, when is you said set it out 1 week? Ms. Underwood, you said to set it out 1 week?
Yeah, but he has to get out to work to make some money, Your Honor.
Okay. So Ms. Adams, 2 weeks, Ms. Adams, do I have in front of the court today? Right.
Judge, her
Ms.
audio is
Adams,
not for some reason.
say it again, Ms. McGreen.
Becky's audio is not working for some reason.
Oh,
I
can
can
you
hear
hear
her
me?
talking. Oh, there you go.
July 1st or July 8th?
All right, I'm gonna set it over to July 1. I'm gonna set a bond, Ms. Underwood. I'm not gonna release him again. He doesn't make payments when I do release him. So I will set a bond in the amount of $200. And I'll set it over to July 1 at 8 a.m. So you can pay the 200 and get out. Otherwise, I'll see you back July 1 at 8 a.m. Unless you want. All right.
Mr. Spresser?
Yeah. I was supposed to be working today, so I don't know. I can try to get a hold of my boss.
So, Mr. Spresser, okay, that's fine. Try to get a hold of your boss, but you know, I let you out and you don't make payments. I mean, I'd be happy if you made minimal payments every week, but you just dip out on me and then I don't see you. So I'm gonna I'll enter a plea of not guilty. I'll set your bond in the amount of $200 and we'll see you back on July 1 at 8 o'clock. Thank you.
Thank you.
All right, Ms. Underwood, thank you.
Thank you, Your Honor.
Okay, so Mr. Jackson, Mr. Noe. Let's take this one. Okay, so this is in the matter of Terry Sue Swift versus Sterling Homes of Adrian LLC and Sterling Estates LLC. File number 2019-6257 CK. I have Charles Noe appearing on behalf of plaintiff and Mark Jackson appearing on behalf of the defendant. So this is date time set for settlement conference, pre-trial, I'm not sure.
Settlement conference, I believe.
Okay, so, Mr. Noe and Mr. Jackson, how do you wish to proceed today?
Your Honor, Mr. Noe and I have had an extensive time to meet on this. They've made several efforts to settle. There's been offers going back and forth, but we're still quite a ways apart. We had agreed at a previous pre-trial on Zoom that if we had not settled by today, we would attempt mediation. And we had put forth some names of mediators. My understanding is Mr. Noe is agreeable that we will use Bill Godfrey in Monroe as the mediator in this case. I have sent an email during the wait to Mr. Godfrey's office. I don't have a response yet, but we hope to get this mediated in the late July, early August range. And if it's not successful, then we'll notify the court for a final pretrial and trial date. Obviously, if it is successful, we'll be back to enter a judgment.
All right, so he's scheduled out like October?
Yeah, he's pretty far out more, but whenever, as soon as possible, I guess we'll say. You know, give or take.
All right, so I have to keep a date kind of on my docket. All right.
I don't think this is going to take an extensive amount of his time.
I could probably do a half day.
That's, I thought.
I'd schedule for a
no
half
more
day.
than a day.
I'd schedule for a half day.
Bill take a half day.
Yeah, that's what Bill does for, at least most of the mediations do with him are domestic, but I've done non-domestic mediations with him as well. He's got to go some half day blocks.
So I'm gonna set this for a pre-trial, like a settlement conference on October 4. Am I here October 4, Ms. Adams?
I believe so. I'm checking. Yes, you are.
All right, so I'm gonna set this for a settlement conference on October 4 at 9 a.m. again.
Your Honor, I did just receive an email from Mr. Godfrey's office. And it says, I am currently booking mediations for October and November at this point, and a waiting list for cases in case of cancellation. So could we go out to the mid to late November date?
Yep.
I would think late November to be safe.
So, Ms. Adams, what about November 22nd, Ms. Adams? I don't even know when Valentine or Turkey Day is.
Yes, that's good.
That's the next week, Judge.
Okay, so we'll do November 22nd.
And the court is only doing these on Fridays, is that correct?
Yes. Because people don't like that I do them on Fridays.
At 9 a.m., Judge?
Yes.
Especially those of us that don't usually work Fridays anymore, Judge.
I know. You'd be surprised how many cases settle during golfing season. That's true. All right, very good. I filled out a scheduling order. We'll get a copy of that out to all of you. So, all right, good luck at facilitation. Mr. Godfrey does a great job. All right, thank you.
Thank you, Your Honor.
Thank you, Judge. Nothing further.
You too. Thank you very much. That concludes our